Come on. Come on. All right. Now I think I have everybody. Ms. Beverly,
Yes.
and you have me, counsel?
I do, yes.
Okay, let's then open up the floor. Okay, we are on the record in the 36th District Court. Today, we are calling file number 20160-566. The file is entitled Open MRI of Livonia versus Hanover Insurance, Citizens Insurance, your respective appearances.
Good morning, Your Honor. Harold and Beverly on behalf of the plaintiff P44028.
And good morning, Your Honor. Matt Reddick on behalf of the defendants.
And since we haven't been together for so long, I take it you settled the case.
I'm sorry, Judge, you take it that we what?
Settled the case. You have
No, yeah, we still have the case. A demand has been sent. Last time that we were here, Your Honor, counsel represented that the amounts at issue exceeded the court's jurisdictional amounts, and the court dismissed it. And as soon as court was over, I was able to confirm that the remarks counsel made were not accurate because his client had paid for 4 of the services at a rate of 100%. So we were below the jurisdictional amount. Therefore, the bill that he had with him on the last, at the last hearing, when you add that to what's left remaining, we are below the jurisdictional amount by about $6,000 or so. So this case belongs in front of Your Honor, and we filed a motion, and it's my understanding that maybe in early January, you granted our motion to reinstate this case.
Yeah, there was a stipulated order entered on January the 6th, reinstating the file and indicating that the court had jurisdiction. So where are we on the file?
We are pretty much at the same place that we were. You could put us in a breakout room, but a demand has been sent, and we were paying 100% on scans. I'm not understanding why this case is still in front of you.
Mr. Reddick?
Well, one of the reasons it's in front of the court, Your Honor, is because when we were previously before the court, there was some discrepancies as far as whether this plaintiff was representing subsequent claims for MRIs that would have put them above the level. So there was some misunderstanding as to what was paid and what was remaining outstanding.
All right, could you hold for just a second, please? Yes. Then call IT, because mine says I'm working. Thank you. Bye-bye. Okay, go ahead, please. I'm sorry. Mr. Reddick, you were saying that there had been some question about subsequent scans being represented or not?
Yes, this is a provider suit for a bunch of MRIs, and there were MRIs that were provided like repeat MRIs. And when we were last in front of the court, plaintiff's counsel represented that they were not pursuing those, or she was not representing her client with regard to those bills. And I did not know that there were voluntary payments made. So it was a little unclear what exactly was outstanding. I did get a demand this morning from plaintiff's counsel, and I requested confirmation of what exactly the outstanding charges are and the dates of service. And I think once we have that, then we can be in a position to at least attempt to resolve this.
Okay, this seems to be a file where we seem to have, and it happens from time to time, things just seem to go south. But it seems now at this point, we're at a point where if you're paying 100 cents on the dollar, there really doesn't seem to be much to argue about between you and plaintiff. How about I have you guys back on February 22nd? Does that work for both of you?
I believe so, Your Honor. Just let me check real quick.
That works for defendants, Your Honor.
Yes, That works for me as well.
Okay, February 22nd. (2021) at 10 a.m. We'll have our next pretrial conference. And hopefully we'll be in a position at that point to have a better understanding about what, if anything, we are arguing about. Unless you guys just like to call and talk to me on Mondays, if that's, your thing, we can do that too. All right?
Thank
Anything
you,
else?
Your Honor. No.
Anything else for you, sir?
No, Your Honor.
All right, then what I'm gonna do is I'm going to, assuming I can get this to work. I'm going to release you guys, and I'll go on to my next case. Thank you for coming in,
Thank you.
Thank you, Your Honor.
off the record. Okay. All right. We're having some technical difficulties as is usual. Let's see who we have here in our waiting room. Ms. Oulette, why are you here today?
TrueScan, DeAndre Butler versus City of Detroit.
Okay. I think I have Mr. Becker here for that. Mr. Becker, are you still here?
Hey, Your Honor, this is Israel. You said you're having some problems?
Yeah, Israel, we're not showing up in the courtroom at all. They're showing a blank screen, And-
Courtroom's right there.
and I'm not getting real time with my people when I'm on the call. We had some difficulty connecting to YouTube. I restarted it and tried it again. So I think we're at the point where we're probably gonna be okay now. I'm not
Hey,
sure.
you're live on YouTube. You have to let the participants in, though. They're all stuck in the waiting room. Do you
Was
know how
the
to?
problem. The problem was when I was trying to have a session, the screen was frozen.
Okay, and you just rebooted it and it's now fine?
I think so, yeah.
Okay. Yeah, in the courtroom, of course, like you said, you have to admit the courtroom in. That's why I took over to admit them in. So if you're all set, then I can,
All right,
Get out.
all right, thank you, Israel.
no problem, see it. All right.
All right, so what I'm going to do is I'm going to admit Mr. Becker, keep Ms. Oulette. Mr. Barter will send you off to the waiting room, as well as somebody who's I'm not able to identify. And we'll get one file done, and then we'll get back and we'll get some more done. All right,
That's DeAndre, is the unidentified DeAndre Hallgrove.
are you Aristo 4?
Rest, I'm not sure what that is.
Yeah, well, we'll put you off in the waiting room, sir.
Okay.
Mr. Becker. All right. I should have now Ms. Oulette and Mr. Becker.
Yes, Your Honor. We're here on TrueScan case 20-146-668.
All right, let's call the file. We are on the record calling file number 20-146-668, TrueScan versus City of Detroit. Your respective appearances.
Good morning, Your Honor. Forrest Becker, P72530 on behalf of TrueScan.
Good morning, Your Honor. Teresa Olet, P72765, appearing on behalf of defendant City of Detroit.
All right, Our discovery has been closed in this file since the end of November. Where are we?
We have resolved, Your Honor. We are just waiting for Detroit City Council approval.
Is that correct, Mr. Becker?
That's correct, Your Honor.
All right, then what I will do is I will dismiss the matter without prejudice, noting that the parties have resolved the matter and are waiting for city council approval. We'll send you out a copy of our order and we'll get you on your way.
Thank you, Your Honor.
And thank you both for your patience.
That's good, Your Honor.
We're off
Thank
record on your file.
you.
All right, now, let's see.
Thank you.
Mr. Becker. We can remove Mr. Becker, we can remove Ms. Let. How's my pen? All right, Mr. Barta.
Yes, sir.
What file are you here on?
I am here on credit acceptance versus DeAndre Hargrove.
DeAndre Hargrove here.
Yes.
All right, so you're SPVF. All right, so I'm gonna put you other guys then into my waiting room since I have a pair. Mr. Sheets, I'll put you in the waiting room along with Aristo 4.
Thank you, Your Honor.
All right, we're gonna call credit acceptance versus DeAndre Hargrove. We are on the record with file number 19-178-491. Credit acceptance versus DeAndre Hargrove. This is a pretrial. I'm sorry, date and time for motion. Your appearances.
Good morning, Your Honor. Suzanne Barta, P 65425 on behalf of the plaintiff.
And what is your name, sir? Mr. Hargrove, are you here?
Yes. DeAndre Hargrove.
This is a motion filed by the plaintiff to set aside the satisfaction of judgment. In essence, Mr. Hargrove, they say you gave him a bad check. Where are we on this, Mr. Barrow?
Your Honor, we're in the same place we were before. He gave two checks. He settled the $13,000 claim for $7,000, made a $4,000 payment on May 29th, made another $3,000 payment 6 days later on June 5th. Subsequently, we filed a satisfaction of judgment. I know we've talked about this before. I wish we could wait until these payments cleared before filing that, but our clients don't allow us to do that pursuant to some guidelines and some rules. Both of those checks came back as non-sufficient funds. We then filed the satisfaction of judgment, and now we're asking for the satisfaction to be lifted and maybe set for a pretrial because no payments have been made on this file.
Mr. Hargrove,
Yes.
what do you want to tell the court, sir?
You You know, when I were communicating with them, we tried numerous times to make payments. They had issues on their end. I ain't had no issues on my end.
Do you have the
So
money to, let me stop it right here.
I
Do you have,
got a payment plan I'm willing to work out with them
no, that's
because
not,
I called them and tried to make payments multiple times. They had issues. It sounds easy to blame me. They had issues, and now life goes on, and I'm in different areas. And no, I don't. I don't just got the money like I had it before.
well, sir,
So
you're the one who wrote checks at non-sufficient funds.
no, I didn't, sir. Do you listening to them and you just going off what they selling you? You got no proof of that. I never wrote no bad checks. I gave both of them numerous accounts of mine to try to pull money from my account. They couldn't get it done. I
Okay,
spent months trying to get that money out of my account.
all right, this is
To
my,
get,
I'm going to grant Mr. Barter's motion to set aside the satisfaction. I'll set this matter for a pretrial date, and maybe you guys can get yourselves organized. I would suggest, given your previous history here, Mr. Barton, that should you gentlemen reach some sort of accommodation before our next pretrial, perhaps it would be part of that accommodation that funds will be paid by certified or cashier's checks. That way we have any more issue on that issue. Does February 22nd work for both of you gentlemen, or would you rather go to March 1st?
March 1st would be great, Your Honor.
Does that work for you, Mr. Hargrove?
yes.
All right, March 1st at 10 o'clock.
Thank you.
Hold on, I'm gonna send you something. Now,
Okay.
Mr. Barter, I need 7-day rule, order setting aside the satisfaction, granting the motion. You
Yes, Your
understand?
Honor. Yes.
All right, March 1st at 10 o'clock. We'll try it again, gentlemen.
Thank you.
Thank you, Your Honor.
We're off the record in this file. All right. Mr. Sheets, I see you there. And what is your name, sir? You in the hat. What is your name? You in the hat? You got on a vest? You're on the line here, sir. What is your name? Are you Terrence Black? Sir, what is your name? Hang on for a second, Mr. Sheets. I'm not getting any response from this individual. I don't know which of two cases he's here for.
Right. No worries.
Sir, what is your name? Sir, you're wearing a baseball cap. What is your name? Sir, are you Terrence Black? I can't get him to respond. Sir, what is your name? Let's try one more something else. All right, Mr. Patterson,
Yes, Your Honor. How are you, sir?
morning. What brings you here?
I have, I believe, two matters before you this morning. I believe I'm a little early, but I wanted to get checked in here. Spectre Clinical Labs and Future Diagnostics both versus City of Detroit.
By 11 o'clock?
Correct. I just want to check in and let the court know that I actually am in a settlement conference in other court so I can come back. But I want to make sure the court knew that I was here and ready to go.
I'll put you in the waiting room, go back to your settlement conference, get the
Thank you
case
very much.
resolved, then you can come back and resolve mine.
Thank you, Judge.
Now, Mr. Sheets, have you had any conversation with Terrence Black?
No, Your Honor.
Are you Terrence Black, sir? Are you Jesse Banks? Sir, what is your name? Sir, what is your name? You just took off your baseball hat. You're wearing a vest, but you don't identify yourself. What is your name, sir? I don't know what to do here. Who is Aristo 4? I'll see if I can put him in the waiting room, maybe get him out. He's not responding at all here. All right, sir, what is your name? Sir, you're looking at me on the screen. Turn on your audio. Turn on your audio, sir. Okay, we're not getting. I can't, Mr. Sheets, tell you who this individual is because he has shown a video, but will not turn on his audio. And his identifier is Aristo 4, which is not very helpful. Hold on for just a second. Hello? Hang on. All right, Mr. Sheets, you're on Terrence Black. carried. The number of registered action is 313-962-1516. All right, Mr. Sheets, what I'm going to do is I'm going to give the other side, it's almost 10:30. And if I don't have an appearance from the other side, I'm going to dismiss the matter. So I'm going to put you and Aristo, whoever Aristo is, into the waiting room for another couple of minutes. Then we will call the file and I'll move forward. I can't act if there's anything else here.
Understood. Thank you, Your Honor.
It's getting frustrating. I'm going to do Mr. Sheets' case. Hello. Thank you. All right, Mr. Sheets, we're going to call your file. We are on the record calling file number. Let me let this other person in. I don't know. I don't believe he's on your file, but I'll at least let her in.
Yeah, of course.
We are on the record calling file number 202408481, Terrence Black versus Rima Priest. Could I have your appearance?
Good morning, Your Honor. John Sheets on behalf of the defendant, Reimer Preister.
Sir, are you Terrence Black? No answer. All right, then I'm going to put this individual who has declined to identify himself back in the waiting room. I'm going to move on. All right, the record should reflect that this matter is scheduled for a pretrial conference today by a notice dated January 5 of 2021. The matter is scheduled for hearing at 10 o'clock. It's now 10:31. The record should further reflect that we just called, or I had my second court clerk call the number that we had for the plaintiff in center line and was advised, got the recorded message that the number had been disconnected. It is now 10:32. Plaintiff in the file has failed to appear. Mr. Sheets, what is your pleasure?
Your Honor, we would move for a dismissal with prejudice.
Well, I'll dismiss the matter without prejudice. Knowing that you have appeared, Mr. Sheets, on behalf of the defendant, we have no appearance from the plaintiff. If you just be kind enough, sir, to give me again your bar number, I'd appreciate it.
My bar number is P77706.
Mr. Sheets, your matter is dismissed without prejudice. I note that the plaintiff has failed to appear. We will send out to you today, sir, a dismissal without prejudice on your file. Thank you for coming in and thank you for your patience.
Thank you, Your Honor.
You're free to go, sir. At this time, we are going to call file number 2014446. That file is entitled LVNV Funding versus Jesse Banks. By a notice dated January 5, 2021, this matter set for pretrial today, January 25 at 10 o'clock. It's now 10:35, and we have no appearance from the plaintiff. What is your name, sir? We have an appearance from the gentleman, and I'm not sure who he is since he won't turn on his audio. But in any event, he's not the plaintiff in this matter. If he is the defendant, then he's the defendant and has appeared. But in any event, at this point, 10:35, no appearance by the plaintiff. Case number 2014446 is dismissed without prejudice, plaintiff having failed to appear. We are off the record. We are calling file number 2016056, United Lab versus City of Detroit. By a notice dated January 5, 2021, this matter set for pretrial today, January 25 at 10 o'clock. It is now 10:39. Neither party has appeared. I note for the record that when we were last together on this, we were awaiting a decision on a motion to intervene in a Wayne County Circuit Court case. Neither side having appeared, this case is dismissed without prejudice. We are off the record. Mr. Murray, unmute yourself, please.
Good morning, Your Honor. Happy New Year to everyone. Gad Holland, appearing on behalf of Barbara Chenault.
Okay, and Mr. Murray, you've got the pave master?
That is correct, Your Honor. Good morning, James W. Murray.
Okay, let me give you guys just a second. And I have one person I've been trying to get. You at Aristo 4, please unmute yourself. Turn on your audio. Turn on the audio. Okay, I'm not getting anywhere with him. I'm going to do you guys out. Try to. Aristo 4, are you there now, sir?
I'm here.
What is your name?
Jesse Banks.
Mr. Banks, I was calling you all for the last half an hour and you didn't answer.
I've been trying to work this device until something came up on the phone where I was able to.
Well, Mr. Banks, the plaintiff on your case failed to appear. So I dismissed the matter without prejudice. Now, he may restart it, but for now, you're done today. We'll send out a copy of that order to you. Thank you for coming in, sir.
Thank you, Your Honor.
Frustrating. Let us call case number 2016591. The file is entitled Barbara Chenault versus Postmaster Ashton. Could I have your respective opinion?
Good morning, Your Honor. May it please the court, Gad Holland, 26655, appearing on behalf of Barbara Chenault.
And good morning, Your Honor. James W. Murray, 48047. I represent Pave Master.
Okay. Where are we on this file?
Your Honor, there's a pretrial conference scheduled for this morning, and contemporaneous with the filing of the complaint, plaintiff also filed a motion for summary disposition.
Right. Well, the problem with the motion for summary disposition is that the typical answer when you file a motion for summary disposition this early in the discovery proceeding, the typical answer is discovery is incomplete. So while the court allows filing of a motion for summary disposition, quote, at any time, I'm not at all sure that that is the wisest thing, because as a practical matter, what's going to happen is Mr. Murray is going to say, I just got into the case and I'd like to have an opportunity to have some discovery. Did I kind of read your mind, Mr. Murray?
You did, Your Honor. Thank you.
Yeah. So I think, guys, that I recognize that we have that motions filed, but unless both of you tell me that you are finished with discovery and don't need any discovery, then I think it'll be more prudent to have a period of discovery for both of you. Do you need,
Well,
Mr. Holland?
Well, Your Honor, after 1,000 years in practice, this is because of the singular facts involved. This was the first opportunity I had to file a motion for summary disposition at the time of the filing of the complaint. I thought it was prudent. I have no reason to think that the matter was that there was an unreasonable decision to be made. If counsel is interested in discovery, of course I can't stand in the way. I think that discovery would be futile. Based upon the facts here, this case is really based upon the contractual language. But I can't. It'd be hard to object if he requests discovery. I don't know what we can add. I don't know what we can add to the case in terms of paperwork. Perhaps he wants to take the deposition of Mrs. Chenault. I don't know, but that's where we are.
All right. So the thing is, what I'm going to do. And even in a contract case, there's always questions about what was and was not done. The contract, of course, speaks for itself. The four bounds of the document tell us what the agreement of the parties is. But generally, the reason we have a dispute is that one side says we have an agreement. The other side doesn't say we don't have an agreement. they say you didn't meet the agreement. So that's going to almost always necessitate some discovery. What I'm going to do is I'm going to open your discovery and give you a March 1st return date. Does that March 1st date work for both of you?
It does, Your Honor, on our
At
side.
11 o'clock. What about you, Mr. Holland?
Let me flip the page, Your Honor.
Yes, sir.
Yeah, March 1 is an ideal date for me.
Okay, March 1 at 11 o'clock, we'll try it again. In the meantime, I am opening, Mr. Murray, what do you have in mind by way of discovery? Do you have in mind the depositions or written discovery only?
I'm not looking for a deposition, Your Honor. I think written discovery would be acceptable, at least based on what I know now. But I do have something I'd like to bring to the court's attention, if permitted.
Sure.
Your Honor, this case has been filed 3 separate times. It was filed in 2017 before Your Honor, and Your Honor stayed the case, entered an order that would permit Pavemaster to return to the location and engage in some remedial action. And what happened is my client went back to that location and was not allowed to perform those services. In fact, we got a letter from Mr. Holland that he was not going to allow that to happen. And I had filed a motion for order to show cause against Mr. Holland. And then at that time, he indicated that his potential claim of damages exceeded the jurisdiction of this court. This case has been dismissed 2 or 3 times. I think Mr. Holland potentially, in the absence of an admission by his client that she interfered with the remedial action, could be a witness in the case. I just bring that to the court's attention because it is a pretrial and Mr. Holland can speak for himself.
Mr. Holland?
I have no comment on that, Your Honor.
Here's the situation. I recall that when I had this case earlier, the parties had reached a tentative resolution, and the resolution was that there were going to be actions taken by the defendant. There was a period of time, as I recall, where we had to delay because the resolution was reached during the time that the weather would not permit paving. But if we had a point where we got to the point where we had paving done and we had an agreement that that was going to be done, and you, Mr. Holland, on behalf of your client, refused to permit that, then I have a problem with that, because this was an agreement placed on the record in open court. And if we had an agreement, and I specifically recall having to adjourn this matter once, because the first time I had adjourned it, the weather had not yet broken, and so there could not be any sort of remediation. But if we had a situation where the court, based upon the representations of the parties, had said we're going to have some remedial work done by the defendant, and the plaintiff did not permit that, then we have a major problem here, Mr. Holland.
Your Honor, I will say this. Court has an excellent recall and thousands of cases that appear before you, an excellent recall and the pertinent facts here. In fact, the court had entered an order to stay because of the seasonal problems associated with the remediation. Unfortunately, we disagree with the conclusion that Mr. Chenault was standing in the way of progress.
Okay.
So well, I think that's an issue that we'd have to address down the road. But I appreciate the court's ability to recall the pertinent facts.
So what I'm going to do is this. Mr. Murray, I note your position. And I want to make it very clear that if we had an agreement placed on the record, which was the reason court stayed a minute, and for whatever reason that did not come about, I'm going to have to know why. And if it didn't come about because the weather was bad, or didn't come about because Pavemaster ran out of asphalt, that's one thing. But if it didn't come about because of the conduct of the plaintiff, then this case is over.
I
So
agree
I'm
with
not
the court.
I'm not making a
I-
decision. Let me stop you right here, because neither one of you need to say anything. What we need to do is you gentlemen need to talk to each other so we can have a more, I'd say this, Chair, a better conversation on this issue when we are together on March the 1st. In the meantime, I am going to open written discovery only. March 1st at 11 o'clock will be our next our next Zoom hearing. Has everybody got that?
Yes, Your Honor.
Yes, Your Honor.
Okay. You guys, when I'm done with you, both of you have telephones. Both of you have P numbers. And you don't know what I'm going to do, because judges, who the hell knows what I'm going to do? But you at least know my thinking preliminarily in this matter. So I'm going to release you, gentlemen. I'm going to give you a March 1, 11 o'clock pretrial. I am going to open your written discovery. Thank you both for coming in, gentlemen. That concludes us for the day.
Thank you, Your Honor.
Thank you, Your Honor.
Have a
Stay
good
safe,
day.
everyone.
All right.
Bye-bye.
Be safe. Good morning. Did you get your other case set up, Mr. Patterson?
Yes, Your Honor, I did.
Good. Let's get these done. Let's call your first file, Future Diagnostic Center versus City of Detroit. This is case number 20155-614. Could I have your respective appearances, please?
Good morning, Your Honor. Gregory Pattison, P75963 on behalf of defendant, City of Detroit.
Ms. Nelson, you want to unmute?
Sorry. Good morning, Your Honor. Trisha Nelson, P68707, appearing on behalf of the plaintiff.
All right. And you guys, your discovery's closed, so where are we on this file?
Your Honor, in the underlying case, we participated in facilitation on Friday. It's my understanding that we were able to resolve this portion of the case through the facilitation on Friday. I'm assuming that the settlement write-up will be in this case, but we are resolved as far as I know.
Ms. Nelson, that's your understanding?
Sorry, I was not the one that attended the facilitation. So I'm going to take defendant's word for that because I don't see the note in our file.
All right, so what I'm going to do, accepting your representation as an officer of the court, I'm going to dismiss this matter without prejudice. And then you guys can send me your paperwork whenever you get around to it, okay?
Certainly, Your Honor.
All right, now, we have one more file for both of you, apparently. Let me finish the paperwork here. The next file I have for both of you is 20155-614. 145054. This file is entitled Spectral Clinical Labs versus City of Detroit. Your respective appearances.
Good morning, Your Honor. Tricia Nelson, P68707, appearing on behalf of the plaintiff.
Your Honor, could I get that case number again? Because I was understanding it was Ms. Nelson was not on this particular case.
Are you, Ms. Nelson, are you on Spectral Clinical Labs? Are you with the Dollar Law Firm?
Yes, Your Honor.
Okay, are you?
Oh.
Yeah, this is 201-45054.
Okay, very well, Your Honor. Apparently I was mistaken. Then
I sell the case. That'll make me happy.
Well, Your Honor, on this one, I'm slightly confused. I apologize. If we may go back, because I have at law as the attorney of record for Future Diagnostics, which we just discussed.
This is Spectral Clinical Labs.
Correct, Your Honor. I have two different law firms on these cases, so that's why I'm a bit confused.
Let me go back. The previous case, 201-55614, Future Diagnostics versus City of Detroit. Now, did you appear on that case, Ms. Nelson?
No, Your Honor, I thought you said Affiliated Diagnostics, which is my client. Future Diagnostics is not my client.
All right, so Future Diagnostics has not been heard yet.
Correct.
My apologies, yes. I thought you said Affiliated.
But Your Honor, that case that's the case we did resolve on Friday during facilitation in the primary case in Wayne County Circuit Court.
Okay. All right, so.
I apologize for the confusion, Judge.
That one I can still leave. Counsel advises matter has been settled by facilitation and dismissed without prejudice, correct?
Correct, Your Honor.
Ms. Nelson has nothing to say about it.
Correct.
She doesn't represent the party. Now, let's try it again. Let's try case number 201-45054, Spectral Clinical Labs versus City of Detroit. Your appearances, please.
Good morning, Your Honor. Tricia Nelson, P68707, appearing on behalf of the plaintiff.
And good morning, Your Honor. Gregory Pattison, P75963, on behalf of defendant, City of Detroit.
Okay. I have here an order that I sent out to you guys on January 6th, allowing the plaintiff to file an amended complaint and striking defendant's motion for summary disposition in lieu of answer. Did y'all receive that?
Yes, Your Honor, and we did file our amended complaint. I don't believe we have received the answer to that complaint yet.
Okay, so let me make sure. You have the order from January 6th.
Yes, Your Honor.
And you say you have filed your first amended complaint?
That is correct.
Okay, I haven't seen that. And have Mr. Patterson, have you seen that?
No, Your Honor, I'm actually looking at the Register of Actions right now. That was going to be a matter I addressed with the court, that we have not received an amended complaint.
Okay, well then obviously we're not positioned to do much today. So this is what we're going to do. I presume that the amended complaint is in the mail somewhere, Ms. Nelson?
Your Honor, I have a timestamp copy from November 30th of 2020 is when we filed it. So I will make sure we resend that in, because obviously if you don't have it by now, I'm assuming it's lost. Yeah, and I will email this to defense right now.
Okay, that's good.
Yes, Your Honor. I see on November 30th, looking at the Register of Actions, the order for the amended complaint, but I don't see an amended complaint in the Register of Actions.
Okay, so you'll be filing your answer. And I'll see you guys again on March 1st. Does that day work for everybody?
I'm sorry, March 3rd or 30th?
March 1.
Oh, see? Okay.
Yes, Your Honor, that should work just fine.
Ms. Nelson, next time have caffeine before you come on.
Yes, I'm fine with March 1st.
Okay.
And Your Honor, that's at 11 o'clock?
That'll be at 11 o'clock.
Very well, Your Honor.
So what I'm going to do is I'm going to send out notice of the March 1st pretrial. And given the fact that this is a first party case, I will require you, now that we have another complaint, to make the 2306 disclosures. And that's all I'm going to do by way of opening your discovery. And if we think we need more, we can certainly fight about that on March the 1st. Is there anything else we can accomplish today?
Not from plaintiff, thank you.
Mr.
Nothing more, Your Honor.
Okay, so here we go. March 1 at 11 o'clock will be our next pretrial conference. And we'll require the disclosures under 2.306. And of course, we'll need the answer to the first amended complaint. Thank you both for coming in March 1st at 11 o'clock. We'll try this one more time.
All right, thank
Very
you.
well, Your Honor.
Okay, thank you.
Thank
That
you.
concludes our docket. We're off the record.